Ever wondered how a simple argument turns into a full-blown court case? Well, today we're diving deep into the life cycle of a civil lawsuit. We're going to trace its path from that first disagreement right up to the final verdict. And our guide for this journey? India's Civil Procedure Code. So let's jump right in. You know, at its heart, every lawsuit is really just a story, right? It kicks off with a dispute, maybe over property, a contract, you name it, and it ends with a final judgment. We're about to walk through that exact journey, step by step, to see how the law creates order out of conflict. Okay, so where does it all start? Well, here's the thing. You can't just take any old argument to court. The very first step, the first hurdle you've got to clear, is making sure your dispute is actually the kind of case a civil court is designed to handle. And that brings us to our first big legal term, a suit of a civil nature. Honestly, the best way to think about it is like your entry ticket to the courthouse. If your case involves private rights, we're talking property, contracts, personal status, then you've got a suit of a civil nature. At the end of the day, that's what these courts are for, sorting out private disputes between citizens. So check this out. Section 9 of the Civil Procedure Code basically sets up what you could call an open door policy. It means the civil courts are the default place, the go-to forum for these kinds of problems. The rule of thumb is, unless another law specifically says, no, you can't bring this here, the civil court's doors are open. Okay, great. So you've confirmed you have a civil dispute. But hold on, you can't just walk into the fanciest courthouse you see. Nope. The next step is absolutely critical. You have to find the right court, the one that actually has the legal power to hear your case. And that brings us to the all-important concept of jurisdiction. And believe me, this isn't just about picking the closest location. This is about fundamental legal authority. Get this wrong, file in the wrong court, and your case could be dead in the water before it even starts. The consequences are huge. Let's break down the word itself, jurisdiction. It's actually pretty cool. It comes from two Latin words, juris, which means law, and dicto, which means to speak. So jurisdiction literally means the power to speak the law. It's the court's official green light to hear a case, decide it, and then enforce that decision. Now, jurisdiction isn't just one single thing. It actually comes in a few flavors. You've got territorial, which is all about where the dispute happened. Then there's pecuniary, which is about how much money the case is worth. Now, if you mess these two up, sometimes it can be fixed or waived if no one objects early on. But, and this is the big one, look at that first one, subject matter. This is about the type of case. A court that deals with family law has no business hearing a corporate tax dispute. And if you get this one wrong, look at the effect. The court's order is a total nullity. It's completely void, as if it never even existed. And don't just take my word for it. The Supreme Court laid it out perfectly in this landmark case. They said a decision from a court without jurisdiction is a nullity. It's nothing. This just hammers home the point. Getting jurisdiction right isn't some minor detail you can gloss over. It is the very foundation of the court's power. All right, we found the right courthouse. Now the real action starts. But not with shouting matches, it starts with paper. We're entering the pleading stage. Think of this as the opening salvos in a paper battle, where both sides formally draw their battle lines. So this paper battle boils down to two core documents. First up, you've got the plaint. This is filed by the person suing, the plaintiff. It's their side of the story, what happened, why it's wrong, and exactly what they want the court to do. In the other corner, we have the written statement. This is the defendant's response. And here's a super important rule. You have to deny every single allegation specifically. If you just ignore a point made in the plaint, the court assumes you're admitting it's true. So yeah, these two documents are literally the foundation for the entire case. Okay, so the plaintiff has filed their case and laid out all their claims. But think about it. How does the defendant even find out they're being sued? The whole process would grind to a halt, right? Well, the court has a formal way to handle this, and it's called a summons. And let's be clear, a summons is not a friendly invitation to chat. It is an official, legally binding order from the court. But it's also something much more profound. It's the system's way of ensuring one of the most basic principles of fairness, something lawyers call audi alterum partem. It's a Latin phrase that simply means hear the other side. I mean, it's just common sense, right? You can't have a fair outcome if one of the parties doesn't even know there's a case against them. Because this is so important, the court has a whole playbook for making sure the summons gets delivered. The gold standard is personal service. An officer of the court hands it to the defendant directly. Can't beat that.
If that's not possible, they'll try sending it by registered post. Sometimes, to move things along, the court might even let the plaintiff deliver it themselves. And if it really seems like the defendant is dodging and weaving, trying to avoid being served, that's when the court can authorize what's called substituted service, taping it to their last known address or even publishing it in the newspaper. The goal is simple: leave no stone unturned to make sure they know. So, let's fast forward. The arguments have been made, evidence presented, and the judge finally issues a verdict, a judgment. But what's to stop the loser from just trying again, filing the same case tomorrow? This is where the crucial idea of finality steps in, to make sure a judgment is actually the final word.
I mean, really think about that for a second. Imagine if you could just keep suing someone for the same thing over and over and over again. The legal system would be complete chaos. It would never end. So, the law has a very powerful tool to prevent this exact scenario. And that tool is a doctrine with another Latin name, res judicata. Let's break it down again. Res is the thing or the matter. Judicata means judged. Put them together, a matter already judged. It's a simple but incredibly powerful rule. It says that once a proper court has given a final judgment on a specific issue between specific people, that's it. You can't relitigate it. It is the law's definitive way of saying, case closed, move on. So why do we have this rule? Well, it's not just a technicality. It's based on three really important ideas, three pillars of finality, you could say. First, simple fairness. Nobody should be dragged through the mud for the same issue twice. Second, it's for the good of the public. There has to be an end to lawsuits, otherwise the courts get clogged. And third, it's about respecting the system. A court's final decision has to mean something. It has to be accepted as correct. Now, it's really easy to get res judicata mixed up with its close cousin, res sub judice, but they do different jobs. Think of it like this. Res judicata is a giant red stop sign. It completely bars a new trial on a decided matter. Res sub judice, on the other hand, is more like a pause button. It puts a temporary hold on a second case when a similar one is already running, just to make sure we don't get two different courts giving two different answers to the same question. And there we have it, the entire journey, from start to finish. We begin with filing the plight. We find the right court by checking jurisdiction. We draw the battle lines with the pleadings. We make sure everyone knows they're in the fight by serving a summons. And finally, we get closure with the powerful principle of res judicata. Which really leaves us with a final, pretty deep question, doesn't it? A term like res judicata sounds all technical and legalistic. But when you peel it back, it gets to the heart of what we expect from our legal system. Because if a judgment is never truly final, if you can just keep fighting the same battle forever, is there ever any real justice? Is there ever any real peace? Something to think about.